The Honorable, the Supreme Court.
Good morning, everybody. Thank you very much. Please be seated. And before we call the case, we have counsel for one of the parties on video. Just clarify that for us. Who is on video and who do they represent?
Attorney Jenny Wang is remote, representing Appellee Lincoln National Group, doing business as Lincoln Financial Group.
Okay, thank you. Welcome. And counsel, can you hear us all right?
I can, Your Honor. Thank you.
And we can hear you. So let's go ahead and please call the case.
Good morning, Your Honors. The matter before the court today is the case entitled Victoria DiMonda versus Lincoln National Group, doing business as Lincoln Financial Group et al. Case number 24 AP 336. Representing the appellant, Victoria DiMonda, is Chris Dodig. Seated at counsel table with Attorney Dodig is Sarah Standiford. Representing the appellee, Marcia Barrows, is Alexander Dean. Representing the appellee, Lincoln National Group, doing business as the Lincoln Financial Group, is Jenny Wang. Representing the appellee, Vermont 504 Corporation, is Bernie Lambeck. Appellees will be splitting time, with Attorney Dean on behalf of Ms. Barrows first, followed by Attorney Wang remotely on behalf of Lincoln Financial Group, followed by Attorney Lambeck on behalf of Vermont 504 Corporation.
Okay, that's very helpful. Thanks for spelling that out for us. I appreciate it. So we'll hear from counsel for the appellants first, of course. Before you start, I want to welcome Pages from next door. This is group 3. Is this, huh? Yeah. Welcome, group 3. I hope we get a chance to meet you individually. I'm sure we will at some point, but thanks for coming over, and we're glad to have you here. Come back anytime. So, counsel, if you would please go ahead. Start, if you please, by introducing yourself and identifying your client for the record.
I will, Your Honor. My name is Chris Dodig from Donovan O'Connor and Dodig on behalf of the appellant Victoria DiMonda. And with me today at counsel table is Sarah Standiford from the same office.
Thank you very much.
I'd like to begin by taking just a moment to thank the court, the clerks, and the staff here for being kind in terms of scheduling and allowing us to argue this in April rather than when we all could be here. I certainly appreciate it, and it is a pleasure to be here.
Thanks very much. Glad to have you.
During the marriage of Victoria DiMonda and Jonathan Barrows, they, like many young couples, elected to use life insurance as a financial planning tool. They had young children. At the time of the divorce, as spelled out in the divorce order and the agreement before it, the children were 6, 9, and 11.
Mr. Donovan, all the policies that were in place were all term policies. There's no whole life policy.
That's correct. As far as I know, they were all term policies. So the children were 6, 9, and 11, a young family, and one of them, Mr. Barrows, was in the military, away from home for months at a time, and he was the primary wage earner, while my client, the appellant, Ms. DiMonda, stayed home with the children, was a homemaker, and worked very little. So under those circumstances, they, like many families, chose to employ life insurance to secure financial future if something happened to the wage-earning husband. And, you know, when a family does that, they're not thinking, well, gee, this will secure child support or potentially college. This will secure my spousal maintenance. This will secure, you know, me paying off our mortgage. It's just general financial security when a life insurance policy is purchased. And then when that couple unfortunately faced the prospect of a divorce and started working out the terms of the divorce, they, of course, looked at this asset and said, we have $400,000 in life insurance on Mr. Barrows for the benefit of then Mrs. Barrows, now Ms. DiMonda. What are we going to do with that? And they thought about, do we continue, of course? And if we do, how long do we continue that life insurance policy? And what they did was they made the entirely reasonable choice to continue that life insurance for 15 years. Their youngest child was 6. 15 years would take her to her 21st. This, in fact, 2025 is her 21st year, and she remains in college. So it was an entirely reasonable thing to do for this family to say, we're going to have you provide support to this family for another 15 years based on where they were in life. And when a family like that reaches that agreement and takes it to the family court as an agreement they reached for support to be 15 years, the family court, in this case, just Judge Carroll, now Justice Carroll, under this court's decision, starting with Justice versus Risk, is entirely entitled to endorse that order, even if someday it might, with an untimely death, result in the appearance of securing spousal maintenance.
Well, let me interrupt you there if I could. I assume you're not quarreling with our case law that says that post-mortem maintenance, because I mean, we all know you haven't gotten to it yet, but the spouse, ex-husband passes away in what, 2023 or?
Yes, the end of 2023 is my record.
2023. But you're not taking a position in this case, as I understand it. I want to be clear, make sure I'm clear on the record with you, that you are not claiming that the law allows for postmortem maintenance, are you?
I am not, though I do note that the decision in Justice versus Rice was a 3-2 decision with Judge Cohen writing a very, Judge, who was it that wrote the dissent? A very well-reasoned dissent in that case, but I'm not asking for an overturning of that.
It wasn't me, so.
No, it wasn't you. But I forget the name at this moment and I don't have time to go look for it. But there was a well-reasoned dissent for 2 of the justices at that point in that case on that issue. But we are not asking that be overturned. We are within that framework saying the parties, but that case also says very clearly that while a court can't on its own order anything that would amount to post-mortem spousal maintenance, the parties are at liberty to agree to it. And if they bring an agreement to the court, it may endorse that agreement.
So the trial court here found no ambiguity in the stipulation that was incorporated into the final order. And it also concluded that there was no, I forget the language that he used specifically, but essentially he concluded there was no intent on the part of the parties to have the stipulation be enforceable outside the limits of the divorce court itself. That's what he found.
He did, but I disagree with him, and we're asking the court to review that.
On what basis in the document itself do you argue that it reflects their intent to have it enforceable outside the divorce?
First of all, let me acknowledge that we're now switching from the enforceability of the court order to the enforceability of the agreement.
Right.
But on that agreement, the document itself says that the parties intended for it to be enforceable. It says it in a number of places, including the release language, where it says, we release all claims against each other. We release all inheritance rights against each other. But accepting from that release, we retain the right to bring suit under this agreement. So they explicitly retain the right to bring suits under their agreement. So right within the document, it says that, and we called that to the trial court's attention in a motion for reconsideration it did not act on. I also point to this court the other factors this court has identified to consider on that issue under the estate of Ladd, and then the reiterated those criteria in the Mayer case, which a number of the justices presently sitting did participate in, said, we look to see, was it a comprehensive financial settlement? This was. Did it waive inheritance rights? This did. Did it contain any language saying it was contingent upon the approval by the court? This did not. So all of those factors we submit demonstrate that the agreement is valid. But I turn backward and say even more strongly that where a party agrees to these terms, the trial court, the family court, was at liberty to include them in their order, and that order becomes a valid and enforceable order.
But Mr. Donnick, how can we factor in what potentially could be a set-off? So he paid, there's no dispute that he paid all of his spousal support till he passed away.
That is true.
And so, and that was well over $400,000 if you do the math.
I don't remember the number, but he did pay a lot of spousal support over those
So
years.
how can you say that the $400,000 policy was not there to guarantee the spousal support? Because if he died 14 years, if he pays all this money in, then he dies on the 14th year, she would get entitled to the $400,000 as what?
I think that it is the same as a family looks at life insurance in the beginning of their marriage. It is to secure everything financial in their life, whether it's child support, children going to college, whether it's spousal support still owed, whether it is, property to pay off a mortgage or something else like that. But I also point out to the court, this is the nature of this type of life insurance. It's all or nothing. They could have and chose not to prorated the distribution of the life insurance, 200,000 in the first 5 years, 100,000 if it's in later years and so on. But they didn't. And this court should not reach into that contract and that agreement reached by this family very reasonably, I would suggest, and change the terms of what they agreed to. This is just the nature of life insurance.
What is your position on whether or not there's ambiguity?
I don't think there's ambiguity, but we protected ourselves because the trial court respectfully, the superior court, what it did was it said, we find no ambiguity. But then in the next sentence, it said, I see no evidence in the document or outside of the document to support the party's intent. And so we felt necessary to say, look, if you're looking for evidence outside of the document, we have a right to have discovery to pursue such evidence, and we didn't get that right.
Would you agree that if there is an ambiguity within the settlement agreement, that it be construed against your client because her attorney drafted it?
I don't know. I didn't research that, but I would say that the document clearly says that both parties were notified of their right to have an attorney to review the document and participate in the drafting. And we don't know the history and what Mr. Barrows used, whether he had some help that, wasn't on the record.
It was drafted by your client's attorney.
It was, as far as I know. Yes. I mean, we haven't explored that in discovery. Remember, this case as a trial court case, as soon as we started discovery, it went to summary judgment. So we had no discovery at all in this case. I have a minute left before leaving some rebuttal time. Priority of claims. This is what we thought this case was about when we filed it. And it does appear to be an issue of first impression. Should a court order granting a wife an interest in a life insurance policy for 15 years take priority over a second wife who the policy was changed to? Should it take priority over Vermont 504, who later gave consideration? Very briefly, with regard to the second wife, the Court of Appeals in New York and Simmons made it very well reasoned and went through all of the reasons why the court order should take precedence. One of the factors is consideration given. And the other is, and this goes to both of them, both priority over the second wife and priority over Vermont 504. If we rule otherwise, if this court rules otherwise, what is the value of these court orders? The court order says you have to do this for 15 years. If we say that's not valid, then any person can walk out. The court orders it, they agree to it with a spouse, and they walk out and they change the beneficiary, or they change the policy to somebody else, or they leverage the policy so that it's useless and there's nothing left of it. To do that would totally, the court order would no longer be worth the paper it's written on. And I'm going to leave, if I have any time.
Before you leave,
Okay.
was your client ever a beneficiary under the USAA policy?
He was the beneficiary under the USAA policy, is my recollection, was the first, the SGLI.
I know about the
Yes,
SGLI.
I do not know the answer. To our understanding, the answer is no, but we've not explored the beneficiary of that policy from the day it was started to the day of the death.
Thank you.
Thank you very much. Who's going to go first here now? Yeah. All right, come on up, please. Before you start, if you would, for the record, introduce yourself and identify your client.
Thank you, Mr. Chief Justice. May it please the court. My name is Alexander Dean with the law firm of Barr Sternberg. Moss, Silver, and Munson. I'm representing the defendant appellee, Marcia Barrows. Principles of equity and contract law, as established by this court, demand that the civil division be affirmed. Ms. Barrows was an innocent victim here. These are two life insurance policies at issue that did not exist at the time of the divorce. And I want to be clear about that. They were always to Ms. Barrows' benefit. I understand Attorney Dodig's position about, a change of beneficiary. This is not that case. There was no change of beneficiary. And we know that because, that was in the complaint. That is how the complaint was answered. There was no dispute that Ms. Barrows was always
Well, wasn't the deceased required under the divorce stipulation to maintain a policy for at least 15 years?
That's correct, Justice Cohen, and we would concede that it appears that the decedent violated the divorce stipulation by not maintaining that SGLI policy after it lapsed approximately 9 years after the divorce was finalized.
In your brief, counsel, at page 23, you say, what is certain is that the life insurance requirement was to terminate when Ms. Barrows' spousal maintenance ended. That's what the agreement says.
So we get that from the fact that the life insurance was to be maintained, and I'll get the specific language. I believe it was for 15 years, and that was the exact amount of time that compensatory spousal maintenance was to last. So that's why we said that life insurance, it's not directly tied to the spousal support provision, but it's the same amount of time.
Right. However, if this is security for the spousal maintenance, why isn't it a declining amount over time?
If I was negotiating this divorce, Your Honor, I think it should have been declining over time. But the reality is that this was a very typical spousal support provision. There was no postmortem maintenance. There was no insinuation within the stipulation that the parties agreed to postmortem maintenance. And we would submit that this, affirming the lower court, would not only be equitable to Ms. Barrows because these life insurance policies existed to support her family should anything happen to Mr. Barrows. They were not changed from Ms. DiMonda. They were not modified in any way. And Ms. DiMonda received every penny of spousal support that she was entitled to. Compensatory maintenance, as this court explained in Weaver, terminates upon the death of the obligor spouse because their income earning capacity ends.
But the fact that you're saying she got all the spousal maintenance she was entitled to is tying it to the insurance policy. Because you're making the argument now that, well, she shouldn't get the insurance policy because she got all the spousal maintenance. If they're not tied together, then how do you get to tie them together?
The life insurance, Your Honor, secures the spousal maintenance. But the spousal maintenance does not insure the life insurance. The life insurance exists under 15 VSA 762 to ensure a support obligation.
If
But
the
the-
insurance is there for security on the spousal maintenance, let me give you a hypothetical. Year one, after this agreement is entered and after they're divorced, he hits the lottery and pays the spousal maintenance, all that's due in one lump sum. He still has 14 years where he's obligated to keep an insurance policy in effect. Do you agree?
That would be correct. Although if I was representing Mr. Barrows in that situation, I would be filing a motion to modify the moment he won that lottery and paid off his spousal support, because now there's no purpose to that life insurance provision. Would the life insurance provision still be in effect and enforceable? Absolutely.
But also the agreement was signed by both parties in September of 2010. If they had gotten a decree right away, they'd done a stipulation for an order without a hearing or gotten a hearing right away, the 15 years could have been up prior to the end of spousal maintenance.
So not quite, Your Honor. This agreement actually had a date certain. So Mr. Barrows started paying spousal support even before then Judge Carroll signed the decree. It was essentially a form of temporary support. The court just was able to hold a hearing in March just because of the docket at the time. But the support was always to terminate in September of 2026. So even if the decree was signed a little earlier.
26 or 25? I thought it started in two.
Oh, excuse me, about 2025 then, Judge. Yeah, it was, but either way, the life insurance provision, it says that it's to last until 15 years or until Mr. Barrows' spousal support obligation ends, whichever is earlier, and that's a key.
Whichever is later.
Excuse me, whichever is
Order says
later.
Later.
Yeah, I'm sorry, I apologize, Your Honor,
No,
for misstating, but
So if once $400,000 is paid, somebody pays, one spousal support is paid, $400,000, is there any need for the insurance policy?
There's not, and again,
Where does that come from? Where did you get that?
it's not the best written provision, this life insurance policy. The reason I said earlier, because it would make more sense for it to say earlier and not later. Again, though, this was I think one of your honors brought this up earlier. This was a stipulation that was drafted by plaintiff's counsel. If I represented Mr. Barrows, this would have been a different stipulation. To the extent there are any ambiguities as to what the parties intended that are not reflected in the plain language of the contract, those should most certainly be construed in the favor of Mr. Barrows as the non-drafting self-represented party. And this, even if the court were to want to look at, okay, what were the parties' actual intent to the extent there was ambiguity? The problem is that there's no admissible evidence that would be available. First of all, the dead man statute in Title 12, the proverbial dead man statute, Title 12, 1601, would prevent Ms. DiMonda from being able to testify as to Mr. Barrows's intent or their conversations back when they negotiated this divorce 11 years ago. And Ms. DiMonda herself filed for summary judgment in this case, arguing that there was no dispute of material fact and that she was entitled to judgment as a matter of law. So at some point during this process, everybody agreed that no more discovery was necessary. It was only after Judge Barrow's decision that plaintiff is now arguing that, okay, more discovery actually is necessary.
Mr. Dean, the stipulation itself even uses language of maintenance, calling it compensatory, because wife did not work. She stayed home, raised the children, and maintained the household. And husband was able to flourish his career in the military. So I don't see any ambiguity in the language of that stipulation.
We agree completely, Your Honor. This is a very
It's
typical
spousal maintenance.
Spousal maintenance, compensatory maintenance, terminates upon the death of the obligor spouse, life insurance provision, which, contrary to what counsel for plaintiff is saying, this was not intended, the life insurance provision, to be a financial asset that was awarded for the benefit of the whole family. If it was, the life insurance policy would have just been awarded to the plaintiff. It was not. Mr. Barrows was to keep the life insurance policy, naming the SGLI policy or a policy of equivalent benefit, naming Ms. DiMonda as beneficiary. And that also goes into the fact that this was not an independent contract, independent of the family division. I refer to it as a Meyer-esque contract in my briefing. We're not arguing, as counsel for plaintiff, I think, might have insinuated earlier, that the parties did not intend to have this stipulation be enforceable. It's just not enforceable separate and apart from it's a family division stipulation. It's an uncontested divorce that was ratified by then Judge Carroll. We believe that equity and contract principles demand that this court affirm the civil division, and unless your honors have any further questions.
Do you think the husband's in breach of the agreement?
The husband's dead, your honors, so
Well,
it's
understand, but I mean, before he died, was he in breach?
everything that we have been led to believe, I would say that the husband was in breach of the agreement. And my client is not where the remedy comes from, nor is Lincoln or USAA. The remedy was in family court. Ms. DiMonda had the opportunity, this court and the Family Rules Committee have created Rule 4.0G of the family rules to allow an obligee spouse or any spouse to demand financial affidavits, Form 813s, once per year, and the Form 813s list life insurance policies, beneficiary names, and the amounts. When I litigate divorces, I'll oftentimes put a financial disclosure provision in a stipulation to make sure that all the parties know that they should keep each other apprised. For the 11 years that Mr. Barrows survived after the divorce, around, I believe it was around 11 years, I don't have the exact timing, but that was never done. And that failure to keep on top of those financial obligations should not fall on my client. With that, I rest. Thank you.
Thank you. Who's next, please?
Good morning. May it please the court, my name is Jenny Wang and I represent the Lincoln National Life Insurance Company.
Thank you.
The enforceability of the stipulation and the resulting divorce order is entirely irrelevant to Lincoln's alleged liability. The trial court correctly found that the life insurance provision was unambiguous and that the plain terms of that provision did not encompass the Lincoln policy. Nothing in the stipulation of court order prevented Mr. Barrows from purchasing a life insurance policy in the future for the benefit of somebody else. In particular, 10 years after he divorced Ms. DiMonda, he purchased his $250,000 Lincoln policy for his new spouse, Ms. Barrows. And again, nothing in the stipulation and order prevented him from doing that. So there was no contractual obligation or obligation under family law or as a basis to hold Lincoln liable under its contract with Mr. Barrows. What Ms. DiMonda's argument, as far as Lincoln is concerned, boils down to is that it's unfair that she wasn't paid the Lincoln policy benefits. But the problem with that argument is that there's no support under Vermont law or outside of Vermont that supports her equitable argument. And the cases that she cites for that proposition are
Ms.
entirely.
Wang, I just have a quick question. How do you characterize the $400,000 insurance policy? Was it surety as a secure to the spousal support, or was it part of a property distribution? What would you say what would you classify it as? Analyze it as?
Under the plain language of the life insurance provision, Your Honor, it's tied to the spousal maintenance obligation. So it would be to secure the spousal maintenance obligation that was agreed upon. Now, going back to the equitable argument of Ms. DiMonda, again, her argument is it's unfair that she doesn't get the Lincoln policy benefits. And remember, the Lincoln policy has a $250,000 benefit, and it's for the benefit of Mr. Barrows' new spouse, not the $400,000 in life insurance coverage that the parties agreed to maintain. The equitable argument is not supported by any of the cases that Ms. DiMonda has cited. There is no such law. There's no law requiring the double payment of benefits by a life insurer under equitable principles. Lincoln's obligation to pay death benefits was defined solely by its contract with Mr. Barrows. And to hold otherwise would mean that an insurer would need to investigate and adjudicate any potential equitable interest before paying out a death benefit. That would increase expense. It would cause delay in the payment of benefits to the detriment of the insured and their intended beneficiary. Lincoln fully discharged its obligation to pay benefits when it paid Mr. Barrows' beneficiary of record. And that's all I have unless the court has any questions.
All right, thank you. I don't see any questions here at the bench, so we're from counsel for Vermont 504, please. How much time have we got? Let's check in.
Appellees have 1 minute, 40 seconds remaining.
All right, please introduce yourself and your client for the record.
I'm Bernie Lambeck. My client is Vermont 504 Corporation.
Thank you.
A few things are undisputed. That in 2020, Mr. Barrows, Seth Barrows, assigned his USAA policy benefits to Vermont 504 up to a cap of $250,000 as security for a loan that Vermont 504 made
Again,
to.
Mr. Lambeck, this is a term policy. It's only, there's no value to it until he dies, right? It's not a whole life policy where there's accumulating value.
My understanding is it was a term life insurance policy. That's right.
So the only time it has a value is if he were to pass away, correct?
Yes, I think that's correct.
Okay, thank you.
Right. I think I'm just going to have to skip most of my argument. In the reply brief, plaintiff cites only one court case that's responsive to the argument that Vermont 504 made in its brief. The central point that Vermont 504 is making is that the only reasonable way to interpret the life insurance clause in the divorce decree is that it's security for maintenance. There's no dispute that the spousal maintenance was not delinquent. It was not delinquent at all. It's simply the case that when Mr. Barrows died, there was a certain amount that wasn't ever paid, a small amount, $53,750.
Counsel, if it's security for maintenance, then why doesn't the clause just say until spousal maintenance is paid in full? Why the 15-year kicker?
Well, I will tell you, it's my understanding that 15 years is identical to the term, to the time it would take to pay off the spousal maintenance. And the dates coincide under the stipulation. The divorce decree took place a few months after the stipulation, maybe 6 months. I don't have it exactly in mind. And so there's a little bit of discrepancy there that the 15 years it is a little bit before the end of the term of payments of spousal maintenance. But the decree provided for spousal maintenance of a total of 500, well, it was a little more than this. There's no dispute that Ms. DiMonda was paid $540,000 and change. And the amount left to be paid under, had he continued to live, was $53,000 and change.
Okay.
And our claim is that's the only relevant piece here, is that $53,000. I'm sorry.
Isn't the amount of $400,000 in life insurance in the STIP a critical feature of the provision? In other words, they knew from the start that if he died after 12 years or 13 years, there would be less than $400,000 spousal maintenance due.
Sure, it's a critical feature. If he died right away, and had he complied with the divorce decree, then Ms. DiMonda would have recovered the $400,000 policy.
But my question is, isn't it, if you're saying that it's clear that it was security for spousal maintenance, but if it's $400,000 all the way to the end of 15 years, isn't the $400,000 indicate something of an intent?
No, I mean, actually, I don't think it stayed $400,000. I mean, I think it was understood, and it's fairly clear from the way this was structured, is that the balance owed under the life insurance policy would be reduced by the spousal maintenance received.
Yeah.
It doesn't spell it all out, but the nature of it was that it was a security for payment of spousal maintenance. Let me just point to this other case. I understand the question there. The Reeves case, which is cited, it's Prudential Insurance versus Reeves. It's an 11th Circuit Court case. It's cited in the plaintiff's reply brief,
right,
responding specifically to the arguments that we made.
All right. Your time has expired. Thank you very much. Thank you very much.
Thank you.
Yes, sir. How much time does the appellant have, please?
Appellant has 2 minutes and 55 seconds remaining.
Counsel.
Get through these things quickly. Firstly, it was Judge Morse dissenting in Justice versus Reese in the 3-2 decision. I'm sorry, Judge Cohen.
No,
Justice Cohen.
no, he would write a very reasonable decision, without, without any question.
Let me say, on this record before this court, there is at least a reasonable inference that this life insurance was intended to secure child support. It terminates at the 21st year of the youngest child. That's, this couple sitting down saying 15 years, they're looking at how old are our children, where are they going to be in life? She gets 21, 15 years from now, they decide 15 years. That's a reasonable inference. That fact hasn't been explored with the parties, but that's a reasonable inference on the record before us. The life insurance provision expressly contemplated a replacement policy. I won't say any more about that, but it's the same idea. You can't go out and say, well, he told me the court told me we have to keep this $400,000 policy. Next week, I'm going to change the policy and somehow that's acceptable. The language of the provision contemplated a replacement policy. And last, I wanted to just quote to end from Justice versus Reese, courts have no authority to order maintenance to continue beyond the life of the obligor spouse unless the parties have agreed otherwise. The parties agreed to 15 years, and the court, the family court simply endorsed that, which this court has said they actually have authority to do. So that takes me, the court order is valid, and it takes us to the argument about who has priority? And I've already addressed that argument. So with my thanks, I will leave it at that.
Thank you. Thank you very much. Thank you all very much. Please call a conclusion of the hearing.
That concludes today's hearing.